Adam Gutowski, who had been back and forth to the napkin counter several times. Adam Gutowski, who knew enough, even in his inebriated state, to say that if I got out of there, I thought maybe things would calm down. The less people there, the better. I'm going to go to the napkin counter for whatever reason. He could figure this out. Could the defendant? No. But we see after the kick of Colin, Adam Gutowski now becoming involved. Now he wants to try to push Colin out of the way. And in one scene, he does in fact go up to Colin, and you can see them grappling. As people have testified, Alexander Bird, Shane Medeiros, they were grappling, no punches thrown. The only persons who say that Adam Gutowski was punched at that time were the defendant and his friend Jessica West. We can see from the video how their hands are situated towards each other. People say that he came at Colin just pushed him away, and we can see Adam Gutowski getting pushed away to the side of that door. And immediately after he's in that position, we see him coming back at Colin Elders. And we hear through Mr. Bird's testimony, excuse me, Adam Gutowski saying, "We're not afraid of you, we're not afraid of you." And now he's coming towards Colin Elders again. But he's intercepted by Shane Medeiros, who is standing on the far side of the table. And you can see it on the video. As Mr. Gutowski is going back towards Colin Elders after being pushed away, Shane Medeiros rushes up and intercepts him, and then pushes him out the door. You can see Adam Gutowski at that point fall out the door, and then within 1 second, he's back up and in McDonald's fighting with Shane Medeiros. In the meantime, however, Colin Elders has, as the defendant says, spear tackled him and put the defendant on the ground. The defendant, this trained agent, he's put to the ground by this drunk young kid. And we see when that happens, and we have heard it through the testimony, that once the defendant is on the ground, Colin Elders turns away from him. He turns away from him and goes to intercede with Shane and Adam Gutowski. The defendant gets up, and the defendant, who has been touching his gun for several times during this whole transaction, finally pulls the gun. He pulls the gun. He says something. Alexander Bird says, "I'm going to shoot you in the face." Whatever he says, Colin turns around and comes back towards him. The gun is pointed at Colin. The defendant says it seemed like Colin was walking slowly, very slowly towards me. And we see in the video when Colin approaches the defendant, his arms are down at his side. The defendant pulls his gun. He's an arm's length away. He says he makes a close quarters draw. An arm's length away, he shoots Colin Elders. Arm's length away, this expert marksman misses. Colin Elders, who has now been the victim of a deadly force assault, tries to protect himself. He's trying to protect himself. He's fighting now for his life. And we see them grappling in front of the cashier's counter, and we see them fall to the ground. We know that there are 2 more shots, one more of which also misses Colin Elders. Still at close range, still the expert marksman missed him, and one we know entered the chest of Colin Elders and killed him ultimately. Now, there's been a big issue through the testimony as to which gunshot actually killed Colin, second or third. I would submit to you that based upon the physical evidence as you heard through
Can I ask Ms. Wong? Oh, sorry, we can. Just really quick.
I would submit that the evidence through testimony of Dr. Conti Dalways about the angle of the bullet.
State submits?
The state submits, Your Honor.
Sorry to interrupt.
Excuse me. I'm sorry, Your Honor. The state submits that her testimony and the physical evidence showing the angle of the bullet through the body of Colin Elders substantiates the position that Ted Coons testified to about it being the second bullet that entered his body. If you look at that one frame where you see the two of them, Colin Elders and the defendant, struggling in front of the cashier's counter, you see the defendant's gun not in the close quarters draw position like he testified it's supposed to be, but in an upward position pointing towards Colin Elders, who's leaning down. And you can see how a shot fired then would in fact enter his left chest and end up at a slightly downward angle and then hit the right back area of his chest. That, and you have the testimony of Gwendolyn Salzbrenner, who say that before she fell, she saw blood on Colin Elders' shirt in the left area where the bullet went in. You have the testimony of Shane Medeiros and Alexander Bird, who both testified that they saw before Colin fell on the defendant drops of blood, not much, but drops of blood in front of the cashier counter. You've heard the testimony of Alexander Bird that by the time they fell, 3 shots had already been fired, and that when they fell, Colin Elders was seen holding the hands or forearms of the defendant in an effort to keep the gun from being pointed at him. Colin Elders did not know that that third shot jammed the gun. And he still had life enough in him to try to protect himself. And he tried, but he failed, and he died. Now, you have been instructed that there are 2 material elements to the crime of murder in the second degree, each of which the state must prove beyond a reasonable doubt. The first is that the defendant intentionally and knowingly engaged in conduct, and that by engaging in that conduct, the defendant intentionally or knowingly caused the death of Colin Elders. Now, what this means is that the state must prove that the defendant did some act which caused the death of Colin Elders, and that he meant to do that act, and in so doing that act, he caused the death of Colin Elders, knowing that what he was doing would most likely lead to Colin Elders' death. Now, I would submit that the state has proven this beyond a reasonable doubt by the evidence in this case, which include all of the witnesses who testified that they saw the defendant pull the gun and shoot Colin Elders, by Miley Lambeth, the EMS person, who testified that by the time she arrived, Colin Elders was non-responsive, transported to Queens Emergency Center without incident or mishap, by Officer Naki and Sergeant Schreiner, who heard the defendant say, "I shot him," by Dr. Perry, the ER physician at Queens, who testified that on November 5th, 2011, at 3:24 in the morning, he pronounced Colin Elders dead, by the stipulation between the parties that agreed that Colin Elders' wife was identified at Queens Medical Center after pronouncement of death by his brother, Zachary Elders, by the stipulation between the parties that the body of Mr. Elders was taken from Queens to the city and county morgue, where Dr. Conti Dalways performed a post-mortem examination on the body on November 6, 2011, and by her testimony that found the cause of death to be a gunshot wound to the chest of Colin Elders, by the comparison of the bullets done by Cindy Lorenzo, who found that the bullets taken from the gun, the exemplar bullets shot from the gun that the defendant had at McDonald's, matched the bullet that was taken from the body of Colin Elders, indicating same gun, same exhibit, the defense expert Kenneth Amiano, who testified that an agent does not draw a gun unless he intends to shoot it, and they're trained that way, that once the gun is out of the holster, it's drawn by the agent, the intent is to use that weapon. No warning shots, no shooting to aim. When agents shoot, Kenneth Amiano said, they shoot to kill. And finally, by the testimony of the defendant, who said he pulled the gun as he was trained to do, aimed it at Colin Elders, and fired it at him with the intention of stopping him or going for a body shot, knowing that it would kill him.
I knew that those shots could kill him.
This is a deliberate act with the intended and known consequence of killing Colin Elders. That is what murder second is. Now, for a very brief digression of what murder second in the second degree does not require. It does not require premeditation. It does not require that the defendant went out that night partying with his friends with the intent to kill somebody, which was Colin Elders. That's not what's required. It does not require a motive, and it does not require sobriety. In fact, as you've heard through the instructions, the law is clear that self-induced intoxication, that is, going out drinking with your friends, is not negative the state of mind of the defendant for this offense. In this case, the state of mind requirements, intentionally or knowingly, cannot be negated by the defendant's bar hopping, no matter how intoxicated he was. Now, the defense in this case is asserting justification. That is, that the defendant was justified in defending himself and therefore using deadly force. Or the defendant was justified in killing Colin Elders because he was defending his friend Adam Pitowski and therefore was allowed to use deadly force. He's also asserting that as a law enforcement officer, he was justified in using deadly force against Colin Elders because he was making an arrest without a warrant. Ladies and gentlemen, as you've seen, those instructions are very detailed. There are very strict restrictions placed on when deadly force, which is firing a firearm in the direction of someone, no doubt about that. Very strict restrictions on when this can be used, and for good reason. For very good reason. And I would submit that a careful reading of those statutes would show, of that law would show you that these defenses do not apply in this case. There was no reason for the defendant in this case to use deadly force against Colin Elders. He had no right to use deadly force against Shane Medeiros, but he did use deadly force, and Colin Elders suffered for that use. Ladies and gentlemen, I would submit that the state would submit that based upon the credible evidence in the law, the state has proven beyond a reasonable doubt that the defendant did not act in self-defense for defense of Adam Pitowski when he used deadly force against Colin Elders. Nor was he justified using deadly force as a law enforcement officer. The state would also submit that based upon the instructions that you have received and the testimony regarding the use of a firearm, we know that the Glock 26 is a firearm. We know that it's propelled through explosive force. We know that it's semi-automatic because it's the force itself that chambers the new round in the pistol. Cindy Lorenzo testified to all of this. I would submit to you that there is no doubt that the firearm was used in the murder of Colin Elders in this case, and would ask that based upon the credible evidence and the law, we find the defendant guilty as charged.
Thank you, ladies and gentlemen. Let us take 10 minutes. Please remember my instructions.
Rise for the tree.
one brief issue just before we take recess. We were not told by the prosecution
if it's something other than testimony that the jury saw. So, at this point, I'm inclined to permit it, but let me go take a quick look and see if we can find anything that might prohibit this. Okay?
All rise. Court stands in recess. You may be seated.
the camera so that our jury can just step into the jury room? Thank you.
I'll just double check.
Is Mr. Daly here? To come. All right, our jury has left the courtroom, but counsel and defendant are present. A juror, Chair 11, Mr. Farnwald, said that Mr. Daly out there is trying to take pictures of them.
You have an application for Mr. Daly, Your Honor?
I did.
So maybe he needs to be addressed by the court.
Mr. Daly? You're Michael Daly, is that right? You can sit right there, that's fine. Thank you. You know, I just want you to know that you cannot, I'm going to ask that you not take any pictures of our jurors. They sometimes go outside during recesses, but I don't think that that is a time when you can take pictures of them. I want you to know that the rule that the Supreme Court has promulgated, and this is Rule 5.1 of the Supreme Court rules, says that electronic devices may not be used to photograph except as authorized by Rule 5.1 and 5.2, which deals with electronic media, the news media. And and I think this rule applies here in this courtroom, but I'm going to ask you not to take pictures of the jurors outside when they have to go outside for a recess. Mr. Daly, it's because I'm concerned just for the security of the jurors. It's a legitimate concern.
Of course it is. Your Honor, are we on the record?
Yes, we are.
Okay. Well, for the record, I'm fully aware of the safety of the jurors and I've been a photojournalist for a long time.
But you're not with any media outlet.
I'm an independent journalist. Your Honor, I would like to explain further that I was outside. I'm doing a documentary, and I like to have some ambient shots. Whatever I shot of the jury was ambient from the behind. When they were in front, I left my camera alone, and I'm surprised that I was called in because
Well,
I can
it's
assure
been
you
reported
that,
to me.
Pardon?
It's been reported to me.
Yes. So it's a legitimate concern that you should bring up, I understand. And I want to explain to the court that in no way would I compromise the jury.
All right, but I am going to ask that you not take any photos of them outside.
Yes.
Okay, actually, you can't even take pictures in here unless you're, I think,